Let's shift gears to talk about.
No, I want to talk more about Canada and how it's a completely broken country that's come into a tyranny that apparently has a new king, Trudeau, and needs to be saved apparently rapidly.
Well, let's talk about another self-coronated king. His name is
oil. So
the other self-coronated king is Mark Zuckerberg, of course. The last subject on our list of topics today. So there's been a few lawsuits that Facebook has been the subject of, or for which Facebook has been the subject. If I'm to be grammatically correct. Anyhow.
You doing this whole prepositions at the end of sentences bullshit? Oh, come on.
Yeah, of course. Of course.
That's bullshit. I reject that rule. Screw that.
I always try to be as grammatically correct as possible.
I don't acknowledge that rule. It's just a made up rule. Like most rules of English grammar, for that matter, are just made up. They were invented by one author one time and kind of stuck on. But there are, in fact, no official rules. So screw that.
Okay.
We're not a constructed language like the French, man. I'll do it any way I want.
America.
Yeah.
So anyway, so these lawsuits are having to do with Cambridge Analytica in the 2016 election, and Facebook, which of course is a beacon, a model company for, data protection and privacy. They are like the shining standard, of course.
Yeah, that is totally their reputation.
And they have proven this time and again over the years. So no, they've got several lawsuits. I mean, Mark Zuckerberg has had to testify in front of Congress. They've got, a whole situation with the FCC, the FTC. They've got this lawsuit in the Northern District of California. And so right now, it seems like there's a number of controversies coming out of Facebook having to do with how much Sheryl Sandberg and Mark Zuckerberg knew about the whole data breach situation with Cambridge Analytica at the time that it was happening, when they were trying to sort of maybe cover it up, maybe kind of clean it up. I don't know, depending on how you characterize it. He testified to Congress that he found out about it when everybody else found out about it, with the Guardian article that came out to sort of put this whole thing on display for everyone. But apparently there's some discovery that says otherwise, that says that he knew about it pretty much at the time that it was happening. And the controversy right now has been that Facebook has been fighting so hard to prevent the depositions of Sheryl Sandberg and Mark Zuckerberg. And they've been trying to prevent any kind of discovery having to do with them and their knowledge, that the Northern District of California, that judge is fed up. He is totally fed up. And he basically, so I in the title, I said that the judge yelled at Facebook, maybe not exactly explicitly yelled at them, but he basically invited the plaintiff in that case to file for sanctions, to get sanctions, not just against Facebook, but against the partners of Gibson Dunn, their attorneys. He's saying that they were so dirty in all of this, and they're so frustrated with the gamesmanship that the Facebook has been putting on, that he's welcoming sanctions to be filed in this particular case. Have you guys heard about this?
No.
I saw a little bit about it, and I mean, I don't know about where you guys are, but here, like, sanctions against the lawyers is a bit of a big step. Like, if there's, and there's lots of lawyers out there who've gone through an entire career without facing like personal sanctions. That's a hell of a thing.
Yeah, because you've got, I mean, when you have an attorney representing a client in this kind of litigation, and you're trying to protect, your client's information, their position, what have you. You might be getting instructions, from your client saying, I'm not giving this over. I'm not doing this. I will not sit for a deposition. And so that the lawyer can be kind of caught in a difficult place, because number one, you have to zealously advocate for your client. But number two, you also can't be a dirty, dirty lawyer and be engaging in crazy tricks. So, the in order for sanctions to be given also to the partners, also to the law firm, is a big step in the United States as well. Yeah. Kurt, you got any thoughts on this one?
Not in particular, without looking at more at the facts. I mean, I agree with you that sanctions against the attorney are very unusual. And you would expect it to not be the first step along the way. Facebook fighting tooth and nail for this is within their province, and I don't really have much more intelligent comment beyond that. I don't know enough to have an opinion.
Okay. So, well, I guess the one thing that I kind of wanted to talk about here is just it opens up an interesting discussion about discovery. Because when a case goes into litigation, and we get past the complaint, we get past a potential motion to dismiss, whether or not there's one that's been filed in a case, then we get into the discovery phase. And generally speaking, it's very, very, very open. Well, hello, puppy. If there is any kind of information, not only that seems relevant, but seems likely to lead to relevant information, then hello, you have something to say. Hi, puppy. Okay. So, then the lawyers on the other side are most likely going to be entitled to it. So, it's very, very difficult to say, no, sorry, this is private information. But there is a possibility to say, well, this actually does get into other confidential information for some reason. Maybe it's internal business stuff that's unrelated to this litigation, or most of the cases that I dealt with had to do with an individual's private information, like medical information, et cetera, et cetera. So, but there is a way to say, okay, we will give this over, but I think, but at the same time, we will file for a protective order. We'll give you a privilege log. We'll tell you what we're not going to give you, and we'll describe it, and we'll explain why we're not going to give it to you. So that's typically what happens and what's proper. But here, it is highly, highly relevant what Mark Zuckerberg knew and what Sheryl Sandberg knew at the time and when they knew it, right? So anyhow, yeah.
I mean, I think it's reasonable to assume that they were vaguely aware of it and were aware of the crisis and probably were trying to crisis manage it. I just don't know what value that ultimately has at the end of the day. I mean, just assume all that's true. What value does it have to your lawsuit, really? I mean, I'm not sure.
So let's see. Yeah. Let me pull up some tweets here from a journalist that was at this most recent hearing. Maybe we can get some discussion here. Okay. So this is Jason Kint. He's been tweeting about this this lawsuit. So on February 11th, they had a hearing on the subject, and the judge basically already told the plaintiffs to file a motion for sanctions because Facebook discovery conduct has been sanctionable. More coming. The judge already said he thinks the partners at Gibson Dunn should be sanctioned. The plaintiff should be rewarded all costs and plaintiff's fees on the discovery issues. Let's see. Mark Zuckerberg, Sheryl Sandberg, their board and leadership team owe Sandeep Solankin, who is taking one for the team on their multi-year cover-up. He's up now. Judge told Solankin he has to attend all status conferences. He's required to attend all mediation sessions with special master and to make a final decision on Facebook's behalf in all mediation sessions. If he needs to run anything up the flagpole, then the flagpole needs to attend. So whatever's been going on between these parties, it seems like Facebook has been really frustrating this process. Now, another aspect of this is that, when it comes to discovery, judges generally don't like being involved. They don't like getting involved in the sort of tit for tat negotiation that goes back and forth between the parties.
Yeah.
So what happens between the parties is you say, okay, I'm requesting XYZ information. And then the other side says, no, we're not going to give it to you. We object because of this reason, this reason, this reason. And then you have to meet and confer with them. You have to kind of negotiate it out and say, no, you're wrong because of this, or they'll say, no, I'm right because of this. And so what happens is then, typically you end up getting whatever information is proper. Things kind of shake out. But if one side is just being obdurate for really no reason, or maybe not a good enough reason, then you file a motion to compel discovery with the court. And courts, if they find that you could have done more to negotiate this, they typically tend to be a little bit annoyed with you because they don't like being involved. They already have a busy docket. They already have a lot on their plates. And so they tend to get annoyed. So the fact that here this judge is very, very decisive and is really coming down hard on Facebook means that there's been some mad issues going on here in this discovery process. Sorry, Kurt, were you going to say something?
No, I'm just listening.
Oh, okay. So, let's see here. So Facebook's legal team has to turn over all documents from the app developer investigation within 21 days, and within all discovery, any doubts should be turned over to the plaintiffs. Court also said to take any depositions now. It's Facebook's fault that things have been delayed, and if the plaintiffs need to depose anyone twice from Facebook, then they'll be able to do that. That's a lot of power that the plaintiffs have then. And then I guess that was the end of this particular hearing. But the issue here is how I mean, really, I think one of the key things that they are trying to get at here is like I said, just how much the leadership was involved in not just knowing that this issue was happening, but the cover up, so to speak. Right. Because it's like, when we look at these sort of corporate controversies, there's the issue, and then there's the crime, which tends not to be the underlying issue, but the cover up of the issue. So it'll be very interesting to see. I mean, I was very surprised to come across this kind of situation going on with Facebook of all companies, because this is not just some small company that has like a ragtag group of lawyers that they may or may not be paying a bunch of money. This is Gibson Dunn. This is a big firm. So the idea that there has been this much frustration of the litigation process means that they are really getting into an information that Facebook does not want to give up. And it kind of makes me a little bit more intrigued as to what it is that they don't want people to see, right? Like that whole Barbara Streisand effect.
What is so important that you're willing to eat sanctions over it?
Yeah,
I mean,
exactly.
I'm obviously speculating in my head on the basis of no inside information, but I would imagine that even if you do get them for depositions, they're going to be so well coached on their answers that I'm not sure what you're getting out of them in the end that's going to be helpful. I think you can probably get them to admit that they were aware of it at the time. You can probably get them to admit that they were providing some kind of direction on some level, but it might have been very tangential. It might have been just, keep me apprised, and, depending on the leadership structure, it might have been more involved. So depending on the situation there, but I'm not really imagining, I'm having a hard time imagining you're going to get this like Perry Mason moment where they're going to kind of like confess on the stand, as it were, in a deposition, and, give you the case. I can imagine why they're not thrilled about it, because they probably don't want their leadership to be harassed, and they don't want to go into things, and they're not thrilled about the exposure and everything else. But I don't know. Maybe I'm not imaginative enough, and this big law firm knows something I don't know. So
Well,
They're
I
going to
think
get Zuckerberg on the stand, and then they're going to hit him with a logical paradox and shut down his programming.